Hello, everybody, and welcome to our webinar presentation of workers' compensation liability and employment law practices for the coronavirus. The coronavirus is a very big deal, and it's coming at us daily, hourly, and it's dramatic, and it's not good. So we decided to put together a presentation on what it is, and what we should do about it, what the laws are, and liabilities, and everything we could think of that might be helpful to the industry. We're presenting through Sullivan on Comp. Probably most of you listening are subscribers to Sullivan on Comp. It's a multi-volume treatise which covers workers' compensation in California completely. We're really proud of it. We have, I think, over 6,000 subscribers. And today I'm talking like the author of Sullivan on Comp. That is, I'm coming at it from a neutral perspective. Full disclosure, I'm a general managing partner of a defense firm. We do workers' comp, employment, immigration, and civil defense of businesses. And we're throughout the state, about 82 lawyers. But today I'm not going to talk like a defense attorney. Today I'm going to talk like the author of Sullivan on Comp. So we're going to flesh out all the issues, give all the perspectives. We're going to try not to have any particular perspective, but just be informative today. I'm not alone. This is a picture of me on the left, and to the right is Eric Wames. Hi, Eric.
Ugh, I hate that picture. Hi, everybody. Yeah, we need to redo those soon.
Yeah.
Yep, I manage the employment law department and here for all issues employment law related to COVID-19, which you'll find out soon has changed in the last few hours. And we'll update you on that. Literally has changed in the last few hours.
Yeah.
Yep.
So is other things like shutting down Fresno. I just saw that.
Fresno.
Anyway, we also have with us Afsha Randera. She's our immigration law practice leader. And she's not going to take up a lot of time, but we thought it might be valuable to make a few points about what's happening in terms of what's going on between countries and immigration practice. So she's going to join us as well and keep us informed on those points. So without further ado, say hi, Afsha.
I was just gonna say hi, and yeah, thank you, Mike and Eric, for having me on board. I'm happy to help out or anyone who has questions about the employment-based aspects when it comes to immigration. So yeah, I'm looking forward to hearing what everyone has to say and giving a bit of information myself.
Okay, well, our plan for this session is to talk about what the coronavirus is, why it matters, and what an employer may be liable for it. We want to talk about what we can do to protect ourselves and what employers can do to protect the employees at a firm. Also, we want to flesh out the issues in workers' compensation and employment law that potentially affect businesses and employees, what we should do, legal liabilities, so when to provide a claim form, when coronavirus might be considered work-related, what impact that might have, whether benefits should be given to quarantined employees, state benefits and federal benefits. We'll discuss that too.
Yep, and also from the employment law perspective, the big issues are going to be leave, what leaves apply, what the employers can and cannot do, what's paid, what's unpaid, and those are developing as we go as well, depending on which cities you have employees in.
You can send questions in and we'll give our emails at the end. Unfortunately, we have so much information that we probably don't have time to respond to questions on the spot. Also, I wanted to point out that you can download this slideshow. All you have to do is go to the, I guess one of these buttons on the right would be considered, they told me what it was. Oh yeah, the handouts section. So you go to the handouts sections and you can print it out and you'll have a complete copy of the slideshow. Of course, we're always available for advice and questions here at the firm, no matter what. So coronavirus, here's some places where you can find out some information about it. It's important to keep up to date. It's changing on an hourly basis. It's just crazy. I mean, everybody knows this, right? Anyone in business or anyone working for a business knows this, or anyone actually existing in our society knows this. It's news every hour. And a lot of it's dramatic and makes us shift behaviors. So it's good to have these three websites we identified: Centers for Disease Control, World Health Organization, California Department of Public Health. We've got the websites here, and we're going to look at them all the time and make sure we're kept up to date on what's going on.
In addition to those as well, employers are going to want to keep an eye on the EEOC website which does have some information, as well as the Department of Industrial Relations, which is more the wage hour labor components.
And workers' comp.
And workers' comp. And they heavily rely also on what is and what is not permissible by looking at the CDC, WHO, et cetera, as their guidance as well. So keeping an eye on those is really important.
Well, what is COVID-19? What'd you call it? COVID, a slang term that you use when you walked out and said, I don't have COVID or something.
I didn't say anything. I don't know what you're talking about.
I don't know. Anyway, this is part of a large family of viruses, and for those that are less concerned with what's going on, they'll point out that there's, some sort of virus. It seems like every year or so, the bird flu, something, and these are all forms of the coronavirus. This is a new strain that wasn't previously identified, and it broke out. It started in China. We saw all happening last December. We thought it'd be contained just like they usually contain everything, but it didn't. It went all over the world. And so it's here now. In COVID-19, CO stands for corona, VI stands for virus, D stands for disease, and 19 for the year it was identified. So COVID-19 is sort of the moniker. We call it Corona. The funny thing is I heard that the good percentage of the population thinks that you shouldn't drink Corona beer because of this virus, which doesn't speak well to the overall intellectual capacity of our society. But I think Corona beers are probably safe.
Yep.
Generally speaking, unless you're handed to you by an infected person.
But in general, skip the beer and go to the quarantini.
The quarantinis, yeah. I've heard about those. So anyway, the virus is spread from person to person. If we're in close contact with another, we can get it because we breathe it in and out if we sneeze or cough. So we have the 6 feet rule. You're not supposed to get within 6 feet of another person, and that's kind of a rule that everyone's been observing. People are thought to be most contagious when they're most symptomatic, which is, I guess, good, because if they're asymptomatic people, they're not as contagious. But spread might be possible before people show symptoms, and right now we just don't know, right? We know there's, I think I was hearing there was 6,500 cases in the United States, 100 deaths. We don't know how many people are infected because we just don't know how possible it is to spread the disease before showing symptoms. We're going to find out relatively soon, but in the meantime, we're all being quarantined. I've just never seen anything like this. I don't think any of us have. I don't think the world's seen anything like this. So how this is all going to play out is really scary and unknown. It's possible to get it by touching a surface or an object that has the virus on it, and then touching your mouth, nose, or eyes. It's really hard to keep your hands away from your face. I'm not really sure why we always want to put our hands on our face, but we do. We just do it. And we do it involuntarily. So it's not thought to be the main way the virus spreads, but we're still wiping everything down and being extra safe. Symptoms may appear 2 to 14 days after exposure. That's a pretty long period. And that's why, everything's shutting down for a couple, 3 weeks, because we want to see who actually has it and how fast it takes to manifest. The big symptoms are dry cough, fever, and tiredness. But sometimes there's nasal congestion, aches and pains, runny nose, sore throat, diarrhea, shortness of breath. Those happen too. They usually start mild and get worse. And it's even possible to get infected and develop symptoms, but not to feel unwell. You could walk around just being a carrier, I guess. So in March 12th, the World Health Organization declared COVID-19 a global pandemic, which sounds really scary. And it means the worldwide spread of a new disease. It's all over the world, and it's defined as an influenza pandemic, which occurs when a new influenza virus emerges and spreads around the world, and most people do not have immunity. That's how they define it. It meets the definition. It's a pandemic. Why does it matter? Well, obviously it matters because people are getting sick, but how bad is it, I guess, is the question. The true mortality rate isn't really determined. The World Health Organization has reported an early mortality rate of 3.4%, but subsequent studies have lowered it to 1.6%, probably because it's in more developed countries and people have more access to care. I don't know. We have a chart coming up on the next slide, which will show you more about it. But for seasonal influenza, that's the flu, the cold, the mortality is usually well below 0.1%, which means it's at least 16 times as deadly. 1.6%, is that a lot? Well, it depends on your perspective, but it's a lot more than 0.1%, right? So one of the worst things about this disease is it's going to kill a lot more people, at least a higher percentage of people than the regular flu. I mean, it's not the Black Plague, but it's no fun, and it's going to kill people. It's generally mild, especially for children and young adults. As I understand it, we haven't lost any children to this disease, which is a blessing. The older you get, the worse it gets, which is bad news for me because I'm pretty old. Not as bad for Eric because he's younger, more spry.
I wish.
And just hardly even worth paying attention to by Afsha. So it causes, but here's the other thing about it. Not only does it kill more people, but it causes more serious illness. And 1 in 5 people, 20% or so, who catch it need hospital care. And that's bad. I mean, it's a worse disease. It's more severe, and it has more of a demand on our infrastructure. So, you know, you see hospitals setting up tents in the parking lots, getting ready in case it spreads and gets really crazy. Not getting hospital care could lead to more deaths, and it could be really taxing on our infrastructure. We don't know if we can handle it. And so this is another aspect of it, which is really bad. So older people, as I said, and people with pre-existing medical conditions have a greater tendency to die. We have a chart here. You see, if you're 80 years old plus, it's like almost 15% of those people die. So we're all calling our moms and dads and making sure they're staying home and not doing anything, and making sure they have enough bread and chicken. And it goes down. So in the 70s, 8%, 60s, 3.6%, 50s, that would be me, 1.3% die. In the 40s, that'd be you, Eric, 0.4%, and for Afsha, it's just 2.2%. So, and 0 to 9 is 0 fatalities. So thank God for that. And then, of course, it's not just the age, but if you have pre-existing conditions, underlying comorbidities, you know, you got your cardiovascular disease as high as 10% of the people with that will die, 10.5%, diabetes 7%, chronic respiratory disease 6.3%, hypertension 6%, cancer 5.6%. But if you don't have any pre-existing condition, on average, it's 0.9%. So maybe one of the reasons that people that are older get it is because they have a greater tendency of comorbidities. I don't know, but if you're pretty healthy, then you're in good shape. So I'm glad I quit smoking.
Me too. I'm glad you quit smoking.
Yeah, I don't smell so bad.
And the one thing with this chart, and I think it's important that we have these statistics so we get an understanding of where we are. The caveat to that is I don't want employers to utilize these statistics in order to send people home because they fall into a category. For example, somebody, you know, my group of employees that are 65 and older, do I just send them home? And we'll get into why you can't do that, but you don't use these statistics to send people home because you think that they might be at risk.
Yeah.
But we'll get into that later.
There's this whole world about what employers should and shouldn't do and can and can't do. We're going to get into that, but first we're going to talk about immigration and workers' comp. So Afsha, why don't you tell us a little bit about what's going on with global travel?
So I wanted to talk, well, thank you for that introduction. I wanted to talk about, well, first of all, don't panic. Take a measured and balanced approach, because if you've been watching the news, you can see very clearly that there have been multiple travel bans in place. First, we started with the China travel ban because it started over in Wuhan. So no foreign national can come in from China. If you are a US citizen or green card holder coming in from China, of course, you can come back into the country, but you're required to do the 14-day quarantine. After that, we had the second highest risk country was Iran. Then we have a complete ban on people coming in from Iran. Then, unless you're a US citizen or green card holder, and then the last few days we had the European travel bans. So I wanted to have this little section to explain, to be calm about your international staff. If any of your workers are abroad, there are measures that you can put into place, which is the second point here. Narrow the scope of the analysis to its impact on global travel restrictions and the resulting effect on immigration policies for your employer and employees. For example, there are policies in place right now that allow for work and home. So the key questions that you have to ask: what are the travel restrictions? What specific visa types will be impacted? How do work from home policies affect certain visa types? And where does corporate compliance fit into the equation? So I'll talk about that in the next couple of slides. So the international travel restrictions, I outlined a few over there when I was talking about China and Europe, and also Canada is no longer letting in any of their people into the country. Well, they've brought everyone home to Canada, but now they are not allowing any foreign nationals into Canada. So so with your multinational company, be aware of that. As for businesses who have instructed their employees to work from home, they must still ensure that they comply with the Department of Labor rules. So, for example, if you've got an H-1B worker, they can work from home as long as their commute distance is 50 miles away. Otherwise, you'll have to update the labor condition application. Same thing for E3 employees. If you are an L1, TN, or O1 visa, then you do not need to update any information or notify your local office. And one saving grace is that USCIS has stated that they will not be conducting H-1B or L1 site visits for companies that are closed due to COVID-19. And then the next and my last slide on immigration. So in order to safeguard and protect yourself, please document everything related to the coronavirus related instructions from either the petitioning employers or the end client in third-party work site scenarios. At the time that we created these slides, several things have changed because we noted that government offices closing were a potential issue for delays. But right now we've heard that USCIS has cancelled all interviews and meetings until April 1st. So you will be getting interview instructions that will be giving you postponed dates, but this of course is going to cause delays, and there will also be delays at your embassy and consulate sites for your employees when they have their visa renewals and visa applications. So please be cognizant of that fact. So yes, I've mentioned that, and USCIS is implementing a nationwide remote work program for its own employees, which means we have to take into account additional delays. So if you have any further questions about how to get through this difficult time, please feel free to contact us at Sullivan Associates, and I leave it back to Eric and Mike now. Thank you for that.
Thanks, Afsha. Yeah, Afsha, we work mostly with employers who are trying to get people over to the United States. We do corporate work, and obviously there's a lot of roadblocks here, so we'll just have to navigate it one step at a time like we do everything else.
And before we go on, going hand in hand with the immigration and travel issues, and that's why we have three of us here, because there's a lot of overlap. One of the questions that I've been getting from clients is, well, people are traveling back to work and they've been in Italy, they've been in China. Can I not have them stay home for at least a 14-day period and require a medical cert to come back? And the answer is yes, you can. The caution, and it's a caution for everything we're really talking about today, is that when you're applying these policies and you're taking these actions, you have to do it consistently in a way that doesn't look discriminatory. So if you're doing it for one employee, you have to do it for everybody who falls into that category with like jobs. And my recommendation, if you're going to do that, is pull the information that you're getting that says that this is a high-risk area, print it out, make the request for them to go back home, return back with a medical cert in 14 days, just so you have that documentation if you're relying on that information.
Okay, so how does coronavirus fit in with workers' compensation? That is, well, to start with, is it work-related? Can it be work-related? Could it be a proper workers' comp claim? Generally speaking, no, but it's going to be an issue in a lot of different situations. But to start with, why do we care? I mean, obviously, that sounds callous. So why do we care? Well, we care about people that get sick. But why do we care whether someone files a workers' compensation claim? Because it's a flu, right? So most people don't file claims for flus and colds. One of the reasons is it gets better in a short period of time, and there's really no benefits to be had. Little medical care is needed. Well, with coronavirus, we do care more about workers' comp liability because, first of all, more people die, and death claim, of course, is a big deal in workers' comp. It's a lot of liability for one case. There's a need for hospitalizations. Even if applicants don't file the application, hospitals might, if they're not getting paid from another source. So we care about it for that reason. And then there's temporary disability. If people, most people with the flu are off very little time and they could just take their their personal time. But personal time is going to get used up pretty fast here, and they may end up getting not paid. They may have a greater interest in temporary disability, and they may be sick for more than just a few days, might be a couple of weeks or more. There might be quarantine. So, you know, people may want more temporary disability. You know, recently a client sent me an email and asked this question. They said, let's say that someone has a workers' comp injury and then they're accommodated, like they're on light duty or modified duty, and they're still working while they're getting treated. Their work restrictions are accommodated. So Bob falls down and hurts his back, and then they put him in a room sorting paper clips, and he's getting paid, right? And then the employer sends Bob home because everyone has to go home and stop working because they have to be under quarantine for coronavirus. This is discussed in Sullivan on Comp section 9.26 in some depth, but you might be surprised by the answer. Does Bob get temporary disability when he has to go home because of the coronavirus, where otherwise he'd be working light duty? Well, the answer seems to be that most likely Bob would not get temporary disability. Why? Because he's not home because he couldn't do the light duty. He's home because of an unrelated thing, the coronavirus, which is not really related to the work-related injury. So the seminal case on it is a Court of Appeal case, Signature Fruit versus WCA Be Ochoa. And in that case, the Court of Appeals pointed out that temporary disability is designed to replace wages that the employee would have earned but for the injury while on periods of temporary disability. So TD is there for when you would have got wages, but you got injured, so you don't get wages. But I have a quote here. It says, the court said it would be illogical to award an employee temporary disability as a wage replacement, where it is undisputed that there otherwise would not have been a wage to replace. So they're saying, you know, injured workers that are off for reasons other than their work-related injury, they don't get temporary disability. Now, Signature Fruit Ochoa was a seasonal worker case, and so this is something that is definitely colorable on both sides and could be appealed. I think it would be a first blush sort of case for any court of appeal that saw it. I also saw the EDD website that said, it says, and I quoted, if your employer has reduced your hours or shut down operations due to COVID-19, you can file an unemployment insurance claim, which means, of course, that they don't see it as something that workers' comp is responsible for. So, you know, if you have questions about TD, people's entitlement to TD when they go home on coronavirus, it seems the central idea is, you know, are they going home because of the work-related injury, or would they be working even with the work-related injury if not for the coronavirus? And that's going to be the sort of governing principle, I think, that will be at the centerpiece of any defense to TD as it presents itself. But anyway, I didn't put that on the slide because we did the slides and that question just came up yesterday. But getting back to the fundamental character of coronavirus as work-related injury, this would be called a non-occupational disease. And we discussed non-occupational diseases in depth in chapter 5, but we don't hear about it very much because it's a disease that it's defined as one that is not contracted solely because of an exposure to work or because it is related to a particular type of work. It's like colds, flus, little diseases that you get, and you can get them anywhere. You might get them at work, you might get them somewhere else. Generally speaking, non-occupational diseases do not arise out of the employment and are therefore non-compensable. There's a foundational case on this is LaTourette versus WCA Be. It's a Supreme Court decision in California. And they said, look, the fact that an employee contracts a disease while employed will not establish the causal connection. The idea is that you can't really show that it was caused by work because it could have been caused from anywhere. And so we're not going to say it's work related. And I have a long quote here from the Supreme Court here, but they basically say, you know, there's a difficulty showing causation, and there's difficulty proving causation, and there's potential high costs for putting all this colds and flus on workers' comp. I didn't say it, but why do it? Because people get better almost all the time, and it doesn't take very long. So we'll put all that together, and we're going to say non-occupational diseases are not work-related. Now, there's two exceptions to this general rule, and they're pretty interesting exceptions. I'm going to tell you about the foundational cases. Again, you can read about it all in Sullivan on Comp, but these two exceptions, it's interesting to speculate about how they may apply in coronavirus situations. So number one is if the employment subjects the employee to an increased risk compared to that of the general public. So if you have an increased risk compared to that of the general public because of your employment, that's an exception, and then your coronavirus could be considered to be work-related. The second, it's a little harder to understand, but it's not that hard. It's if the immediate cause of the injury is an intervening human agency or instrumentality of employment. That is, if something about employment, something that happens of employment, is the immediate cause of the coronavirus, then that would be considered work-related. And I can illustrate this, and Eric and I will talk about it, how it might play out after I illustrate it with a couple of these cases. So for the first exception, which is that the employment subjects the employee to an increased risk compared to the general public, right? So what happened in Bethlehem Steel versus industrial accident? This goes all the way back to 1943, Supreme Court case of California. There's shipyard workers, and they all got conjunctivitis in their eyes, and it was undisputed that the disease among shipyard workers was an epidemic. And the defendant says, hey, you can get this anywhere. It's a non-industrial, non-occupational illness. No, it's not work-related. You can get it anywhere. They said it's an epidemic also in San Francisco and other places. So the shipyard doesn't count as a special place, which increases the risk just because you work in the shipyard. But they lost. The Supreme Court found in favor of the workers, and it says evidence is quite convincing that the disease in the community outside of the shipyards was of much less proportion compared to the population. So there's a lot of it in the shipyard and not a lot of it elsewhere. And so they said this is a special exposure in excess of that of the commonality. And it found that the employees met their burden of proving the risk was higher in their area. So this is an application of rule number one, right? If the employment causes you to have a higher risk than the general population, then it is work related. And in Bethlehem Steel, that was the basis of its decision. Now, Eric wants to talk, Eric.
I always want to talk, I can't help myself. So looking at this case and applying it to a COVID-19 situation, if you had a city or a county that didn't have that many instances of testing positive for COVID-19, but a particular organization in a city had 4, 5, 10, 15 instances, that would lend itself to being occupational because it's greater in this particular organization than it is in the general population surrounding it.
Mm-hmm.
Would that be accurate?
I think so. I mean, let's say you're the only employer in Los Angeles that doesn't send everyone home, and then everyone gets coronavirus. Well, arguably, right? Because you can get it at home as well as you get it at work. And it's still hard to prove. And you have to show that it was a greater risk. But arguably, you could be providing an environment where there's a greater risk and thus it was work related.
Yep. And by the way, that didn't feel good because I'm normally defense side. So even arguing that made
but I'm neutral.
Had a bad taste.
I'm neutral.
Right.
Another case that illustrates this was Pacific Employers versus Industrial Accident Commission, another 1942 Supreme Court case. But it's a little different because there's a traveling salesman. He lived in San Francisco. And then he travels to San Joaquin Valley. Now, something was going on in San Joaquin Valley called valley fever. It's a respiratory illness caused by a mold or fungus that only existed in the valley in Arizona. So he had never been to the region before his employment, but then he went and he got it. So he says, look, I was in a special area by virtue of my employment. And the defense says, no, there's insufficient evidence to support an award. Even if he did get it in the valley, he can't be said to have risen out of employment. And the Supreme Court said, nope, it's compensable. It is compensable because if his duties hadn't taken him there, then he wouldn't have contracted the disease. It was by reason of an incident to his employment that he came in contact with the infection. And so the risk to which he was subjected was not the same as that of the public. His employment caused him to have a greater risk by reason of his travel to that area. And of course, when one starts to wonder about travel and contracting the coronavirus, I don't know if being on a plane could give you more coronavirus than not being on a plane, but I imagine that argument will be made. So if people travel in their job, maybe that might be a basis for establishing a workers' comp claim. If people have to go certain places where there's a higher concentration, that might be a basis for it. All of these arguments could be made. More to the point, doctors, nurses, healthcare workers, people that work with large numbers of people, right? So if you're a doctor and you get coronavirus and you're treating hundreds of cases, gee, what do you think? Is there a greater risk of getting it in the hospital than in the general population? Yeah, I would think there probably would be. That'd be a pretty good argument, I would guess. One I'd make if I was an applicant's attorney, which I'm not, so I think it's a terrible argument. But that's a potential there. And then, all these areas are on lockdown and you have to stay in your house, except if you're doing vital services, right? So the people that are doing vital services are the only ones out in the world contacting other people. The arguments will be made that those people probably will argue, hey, we were out in the world, we had greater exposure, so our work contributed to the development of the virus. Again, in accordance with these cases, they would have a colorable argument. Okay, so then exception number 2, you'll recall exception number 2 is an immediate cause of the injury is an intervening human agency or an instrumentality of employment. That is, there's something that happened at work that actually caused the injury. It's hard to think about what that might be in this environment, but to look at the cases, the first one was Maher, and this is really the foundational case in this area. It's a 1983 case, and the nurse's assistant had a pre-existing tuberculosis, and she was required to treat it while working, and the treatment itself caused her injury. She had an adverse reaction to the drugs, and she said, look, my pre-existing tuberculosis was treated, my work mandated that I treat it, and so I got sick. And the board said, sorry, that's not compensable because your tuberculosis was non-industrial and you're just trying to keep it tempered down. But again, the applicant won. The Supreme Court said that this injury is compensable, and they said this is an injury sustained as a result of medical treatment required by her employer, exception number 2. The fact that the employer required her to undergo this medical treatment meant that it was work-related. Of course, there's a long-established 1% rule in workers' comp. All it takes is a 1% causation, and it's considered work-related when it comes to injury and every benefit, really, except permanent disability. The quote here is that California law does not require that the employment be the sole cause of the injury, only that it be a concurrent or contributory cause. So it was compensable because there's no dispute that this treatment required by the employer made it happen. This is, a decision in line with exception number 2. There was something at work that was the cause of the injury, intervening human agency or instrumentality of employment. That was good enough for the Supreme Court in this case. So if that's causes injury or death, then it's compensable. It's hard to think about how that might manifest with coronavirus. How would someone get coronavirus from an instrumentality of employment? I don't know. I don't think anyone's going to be. Maybe if someone got treatment for coronavirus and they had adverse reaction to the treatment, that would be. It was required by the employer. That would be enough to fall into this exception.
Like vaccinated.
Yeah.
And it had an adverse reaction.
If the employer required them to be vaccinated, which I think you're going to tell us we can't do.
Well, we'll get to that.
Or if the employer provided vaccinations, right, something like that. So that could come up. Ladies and gentlemen, I think we are going to see a lot of litigation over this in the future. If indeed the coronavirus does become ubiquitous enough, and there's deaths and lost time, and these efforts to contain it don't succeed. These will all be issues of fact, and they will all be very disputable, and there will be a lot of litigation, and us lawyers will have a grand old time wrestling with them.
In both, in workers' comp and in employment law, I think it'll be lots of litigation and potentially new case law surrounding leave laws and discrimination, retaliation components to it is what we really need to keep an eye on.
Yep. Anyway, the third way that there could be an exception to the prohibition on coronavirus being work-related is a little-known labor code. Man, I didn't even hear about this before I wrote the section on Sullivan on Comp. I've never seen it used, and I only mention it because I want to make sure I'm complete in telling you about the different sort of statutory ways in which something might be work-related. There's this Labor Code 3208.5, which pertains solely to healthcare workers, and it says that if there's a reaction to or side effect arising from healthcare provided by the employer to a healthcare worker, healthcare provided by an employer to a healthcare worker. That's just weird. I guess it only happened in medical establishments where they provide care to their own employees. Anyway, if they do that and it's intended to prevent the development or manifestation of disease and they have an adverse reaction, then the statute provides that this would be work related. You know, it's kind of superfluous of the second exception in the Maher case. That would certainly qualify as an event that happened at work, an intervening human agency or instrumentality of employment. So it's sort of superfluous. That's probably why, one of the reasons why we never really see this statute used. But I did want to mention it to make sure that we were complete. And for all you lawyers out there, they're going to want to throw everything you can at, if you get a case like this, at it. I'm going to leave it at that. So what is the government doing about this? Well, we didn't, when we authored this, since we authored this, the federal government's jumping in too. We see Governor Newsom on March 4th declare a state of emergency. Additional resources are made available. We'll talk more about state and federal agencies and the resources they're making available and what's speculated they may do. A formalized emergency actions already underway across multiple state agencies, help the state prepare for the broader spread of it. They're equipping the hospitals and all the other entities that would need to be responsive to a general more aggressive outbreak. It froze prices. You're not allowed to gouge the consumers. So we all go down to the grocery store, buy toilet paper, and there's no toilet paper. But there is some, you know, Frosted Flakes, but they can't double the price of Frosted Flakes. That's against the rules. You can't gouge us just because we're in short supply. It allows for healthcare workers to come out from out of state to assist in healthcare facilities, give healthcare facilities the flexibility to plan and adapt to accommodate incoming patients. There's been 18 public health labs in California that are testing for it. I understood we didn't have testing for it that was really available. I have heard about centers being open where some testing may be done. I know a lot of people that think they may have it or might get it. They're not getting tested. They're just not available. But that's, you know, we have our hair on fire trying to get testing out there, because without testing, we don't even know who's got it and who doesn't. There's no vaccine. This makes it really scary because we just don't even know who's got it, or, you know, what the real incubation period is, or if it can be vaccinated against, or, you know, really much about it at all. It's come on so rapidly. But public health labs are being established in order to start the testing process once we get it together on this. Millions of Californians are now eligible for free medically necessary testing once it becomes available. So certainly this is in our near future. What is the WCA Be doing? Well, they're doing a lot. We found out on Monday that they're going to stop taking hearings on Tuesday, right? For 3 weeks. So what the court said is, okay, here's what we're going to do. We're going to have expedited hearings, but we're not going to have anything else for the next 3 weeks. In fact, all hearings are canceled for this week, and we're going to mail you a new date. And then they said for the 2 weeks after that, at least the 2 weeks after that until April 6th, we're going to have no trials, and we're going to have no lien hearings. And we're just going to send you new dates for those. We are going to allow status conference, mandatory settlement conferences, and priority conferences, but they have to be done by court call. So I read that and I said, what's court call? Everyone knows about court call. Everyone knows it exists, but it's not used very much, and not a lot of people know how to use it. So what we did is we sent, if you're one of our clients, or you're a client of Sullivan Comp, then you will have gotten our email blast or red alert that went out on Monday that explains what court call is in some detail, how to use it, and hopefully you'll be able to follow the steps. Court call is not established, not even mentioned in any statute or regulation, but it is used by courts and used by the WCA Be and it's been used in the past in status conferences, but now evidently that's being expanded. So we're going to want to do that for the hearings a week and the week after. If someone doesn't show up and there's a court call set and a party doesn't show up, it's continued. The presumption, I guess, is that they just couldn't, get it done in time and make arrangements to be there. So no one's going to get hurt for failing to appear in this week and the next 2 weeks after. Now, the word on the street is that court call has gotten really inundated, which is not a big surprise. And as such, they're not really being super effective at getting things done. You have to actually register for court call, either as an individual or a group. So a local law office or a claim shop in a given area can register as a group, but they haven't been responding in 24 hours is what I hear. Just this morning, I got an email from Vet Lopez in our offices, who actually did the yeoman's work on putting together the email on Monday. I hope it's helpful to everybody. And they said, the email from court call said, hey, please verify with your court that you actually have a court hearing date before scheduling this court call. If it got rescheduled, then we don't want to set a date. And then they said live agents can only take orders for hearings on 3/18 and 3/19. That was today. Some requests for later dates or inquiries to email assist@courtcall.com. Do it online if you can, et cetera, et cetera. So if you're doing this, you're going to want to check Court Call's website every day. They have various alerts. They're keeping up to date. They're scrambling just like we are. So it's not going to be a surprise if the majority of cases are just continued for 3 weeks, which is going to put us all at our desk, well, actually at our home desks, trying to deal with our cases.
And for my employers out there, the HR people, civil litigation, it's pretty much the same thing across the board throughout California and almost all of my Superior Court counties. They're being shut down except for essential hearings. Even trials the request is that the judge hearing them either mistries it or continues the trial holding the jury until they can come back.
What about the 5-year rule?
It's likely, if that comes into play, it'll be told because it'll be out of, and what Mike's talking about is there's a 5-year statute of limitations from the time of filing a complaint until the time it is tried, with some exceptions. So the likelihood, if that happens, it's pretty liberal, it'll be told. But that's happening through all of our courts. We do court call in the civil world pretty regularly. So it's not new, but we usually don't like to do it if it's for an essential hearing, an argument of a motion, and it depends on judge, but most judges in the civil world like it because it declutters their calendar quicker and it keeps the courtrooms with less people in it.
There's some areas that have just been put on complete lockdown. People just have to stay in their house. Well, they have to stay in their house, but they're not allowed to go to work. And
the shelter in place.
Shelter in place, yeah. And we got that for the boards in Northern California, with the exception of Sacramento. And just an hour ago, I got notice that they're doing it in Fresno. So they have a more limited one. In Orange, there was an email went out, and then this morning they said, what? That was a mistake. We're not really doing that. Yep. So it's crazy, and it's hour by hour, and there's a lot of exceptions for vital positions and jobs, but it's just changing all the time. For those few cases that end up in front of a judge, we've seen memos from judge posters on doors saying, wait in the hall when you're ready, put the file on my desk, and the physical distancing is emphasized, and the various things you do to make sure that you minimize the chance of infection person to person are instituted. So it's on, and it's changing all the time. What's next? April 6th, will we be back on and back to normal? We don't know. We just don't have any idea. Just like society in general, we don't really know what we're going to do with this. It really is a day-by-day thing. Perhaps we'll be quarantined for a long time. Perhaps people will just say, you know what, the cure is worse than the disease, and we'll back off. I don't know. We'll have to see.
I think, in my experience, our clients that are doing best with these changes are the ones that have and have put in place contingency plans for this, assuming it's going to be more long-term. And that, I think that as a general rule, that is a good idea, to have somebody putting in place a contingency plan for your organizations with the assumption that this is going to be longer rather than shorter. so you can adjust easier as opposed to just being reactionary to hearing the news on a day that you're going to be shut down. I think that just makes good sense. It's going to be easier on your organization.
We're all doing 14-hour days at the management level trying to figure out what to do here. What can you do to slow the spread of the virus? Well, this is what's happening. You got to wash your hands. You got to sing happy birthday while you wash your hands. So it's 20 seconds after you've been in a public place, blowing your nose, coughing, or sneezing. Hand sanitizer, good luck getting some of that, right? It's amazing, the empty shelves in the grocery stores. Avoid touching your face. Contact with people who are sick. Put distance between yourself and other people. If it's spreading in your community, stay home. Staying home is a big issue for the employers, right? We're going to talk a lot about that. Cover coughs and sneezes, throw tissues in the task, wear a face mask, clean and disinfect the surfaces.
Yep. And since we're on it, the question comes up, can we require employees to engage in these practices in the workplace? Yes, you can, as long as you're doing it consistently and throughout all of your employees. On the reverse side, if an employee says they want to wear a mask, is that required? Do you have to comply with that request from an employee? There is no law in place that says you have to do that, especially if you have a forward-facing organization. You may want to consider it anyway. Just because you don't have to doesn't mean maybe you shouldn't in the first place.
Can employers make you wear a face mask?
Can employer? Yes, they can.
Okay.
Yep, they absolutely can.
Yeah. They can make you do it.
They can require, and the defense to that is OSHA has guidelines out there for employers to keep a safe and secure environment for their employees and their clients as a general rule. And implementing these rules, which are out by the CDC and the WHO, et cetera, is a legitimate reason to have employees engaging in those practices, wearing gloves, cleaning surfaces, et cetera.
Okay, so here at the firm, last week we were thinking we'd just come to work, but then suddenly we sent everyone home to work from home. This is something that's happening all over the place. Unfortunately, some jobs can't be done from home, so it puts a lot of employers in a bad position. You either send them home and they take leave. We'll talk more about that, or just send them home without pay or keep them at work. It's a really tough decision that has to be evaluated by each employer. But anyone who has a symptom got to go home. If they're having symptoms of respiratory illness, they got to stay home until their symptoms go away and have gone away for at least 24 hours. We're requiring a doctor's note upon return in these instances, but what if there's not doctors available? That's a possibility if this thing breaks out any further. So employers will have to make judgments about that. We have to have flexible sick leave policies, but we don't want anybody with any symptoms at work. And if somebody's home and their family members have symptoms, they shouldn't come to work as a prophylactic measure, even if they're not sick, because it can be latent, and so you could be infecting everyone at work. Every employer is going to have to look at their business, look at their situation, and make judgments about what they're going to require of their employees and assess the impact it's going to have on their business and the employees. You don't want to separate sick employees, so we have, we can send home all the paralegals and the lawyers, they can work from home, but there's 8 employees that have to scan physical documents that are mailed to us. They have to be in the office, so we spread them out all over the office so they're not next to each other. Emphasize staying home when sick, perform routine environmental cleaning, right? So we're routinely getting all the bugs out of the office and cleaning the office extra careful with disinfectants. Consider carefully travel. The truth is, and we also have here postponing or canceling large work-related meetings or events. Look, in workers' comp, all the conferences are just canceled, right? It's just not happening. No one's going. When we set a happy hour or get together or something with clients or dinner, even in-house activities, team building activities, what we're seeing is that they're just getting canceled. No one wants to go. The employer thinks it's a bad idea for people to go. So it's all just coming to a halt, which is bad for economics, right? But it just seems like to be what we have to do. Employers may make the decision about postponing or canceling these things, but it may be a decision being made for them by the clients, by the employees. Traveling is the same sort of thing. If we're not going to have meetings, we don't want to have physical meetings, we want to have telephone and Skype meetings and such, we're not going to be traveling. And so we're just seeing this dramatic drop in traveling. Of course, the airlines are asking for federal assistance because there's just nobody on the plane. And we want to look at flexible work policies, work sites, work hours, increase the distance between employees, infrastructure to support multiple employees. You may be able to work from home. So we sent home everybody and we said, if you don't have the bandwidth on your internet, then let us know and we'll give you that. Incidentally, Eric will tell us more about it, but if people use things at home for work, then they're entitled to compensation for that at a reasonable rate. So I think we give everyone $60 to compensate them for their internet use and perhaps any equipment they have at home that they're using for work. And that way we don't run into a wage and hour problem. And they're fairly compensated. We told them if it's not fair, let us know and we'll figure it out. So that's another element that has to be thought about with employers when they talk about having people work from home.
Yeah, what Mike is talking about is the reimbursement code under the labor code for 2808. You do want to pay attention to the fact if you're sending employees home that they get reimbursed for reasonable expenses incurred for doing the work. Just because they already have a cell phone doesn't mean you don't have to pay a portion of that. Just because they have internet doesn't mean you don't have to pay a portion of that to a reasonable extent. And every company is going to have different types of needs that the employee's going to have to fulfill. Just give them the opportunity to be able to submit those types of reimbursements so you stay wage and hour compliant.
Yeah. Now, what if Bob has symptoms and goes home? Can you tell the other employees, hey, Bob had symptoms and he went home?
Absolutely not. So what you can do.
You can't?
No.
Why not?
So when, and this will happen and could happen, is if an employee has symptoms, is one thing. Can you send them home? Absolutely. Can you send Bob home? You most certainly can without even a confirmation that he has COVID-19 in this world. We'll get a little bit more into that later. But do you say Bob had symptoms, everybody? No, because these are medical conditions, even if it doesn't rise to a level of disability, and you're still required as an employer to keep those confidential. What you can do is tell employees that there are people in the organization that have displayed symptoms, or God forbid, somebody in the organization tested positive for COVID-19. You are required to tell employees that. You just are not allowed to reveal the person who had them.
So if anybody worked closely with them, you're probably going to send them home. Clean the affected workspaces. You don't want to quarantine people who may be at risk by virtue of the fact of working closely with people that have displayed symptoms. If you still have employees in the workplace, which doesn't seem like a lot of people do. If you have a sick family member at home, you should notify your supervisor, right? And that person should go home, because a person with a sick family member at home is at risk. And so they're just like the sick family member. They have to stay home until that sick family member, or they, if they get it, are cleared with enough time, 14 days, to make sure that there's no infection coming into the workplace.
Yeah. If somebody is caring for a family member that either has the symptoms or tests positive for COVID-19 that you know of, they can also be sent home. But what you don't want to do is start inferring somebody might be exposed because that family member is in a high risk category, like elderly, or is receiving chemotherapy treatment, those types of things. Don't infer those things, but if they tell you that they're displaying symptoms and have COVID-19, you can take that action.
Okay. And then the next topic I want to talk about is whether you have to provide a claim form, right? This is a big deal in workers' comp, is the duty to provide a claim form, because once a claim's filed, there's a workers' comp claim. And it's an area which I find surprisingly is misunderstood by a great many practitioners, in that most people think a claim form has to be provided in situations where it doesn't. Does it have to be provided when someone presents with symptoms, or say, hey, I have the coronavirus, or says, hey, I got the coronavirus at work? Well, I'm going to run down the law for you quickly here. There's Labor Code 5401A. It says the claim form has to be provided within a day if there's knowledge of an injury under 5400 or 5402. Okay, so what that means is if the employer has knowledge of an injury and that the injury is work-related, if they have knowledge of a work-related injury, not just an injury, but a work-related injury, which results in lost time or medical, then you have to provide a claim form. Well, the foundational case on this is Honeywell. Honeywell's a big deal in 2005 because before Honeywell, everyone thought you had to provide a claim form if you had notice or knowledge of injury from any source, notice or knowledge. But that's not what the statute says. It says, well, it does, receiving notice or knowledge, but Honeywell interpreted it to mean that you have actual knowledge of a work-related injury. So the California Supreme Court held that the duty to provide the claim form arises when the employer has been notified of an injury in writing by the employee or has knowledge of the injury from another source. So you have to know it. You have to know that there's an injury and that it's work-related as an employer. Now, what Honeywell distinguished is what they called reasonable certainty. Does the employer have reasonable certainty that there's a work-related injury? And if the employer has reasonable certainty, they do not have to provide a claim form. They have to know it. And that was a distinction made by Honeywell. So you can see it's a pretty high standard because there's a whole lot of situations where you would have reasonable certainty, but you wouldn't necessarily know. And that's the standard that Honeywell puts out. So the duty arises when the employer knows of injury or claim is filed, but it does not arise when the employer should have known or reasonable certainty that injury occurred.
So in the COVID-19 scenario, how would an employer ever know for sure? Because an employee could get it anywhere.
Well, I didn't say no for sure. I said no, as opposed to being reasonably certain.
Well, how would an employer know?
I think my judgment is that they wouldn't, because they may know that someone has the symptoms of coronavirus. They may know once we get testing, they may know that they have it. But in order for it to be a work-related injury, they'd have to show the exceptions we talked about before, fundamentally that the work caused an increased risk of coronavirus. You'd have to know that. And that's not an easy thing to know. So it seems to me that in most, if not all of the cases, a claim form won't have to be provided because an employer may want to, okay, but they don't have to provide it, I don't think, because I have a hard time seeing it past the level of reasonable certainty. Now, look, a lot of applicants' attorneys may disagree with me, and I'm not trying to advocate for one position or another. It's just that I'm telling you what Honeywell said, and I'm having a hard time under the standard under Honeywell of showing that there's a work-related injury. You did not see a beam come fall on the guy's head. You did not see that. That's not what happened. You just know this guy's sick. Generally speaking, being sick is not work-related, and it has to be a special reason. And you have to really know about that special reason, I think, in order for it to be required that the claim form be provided. I put down here that Honeywell has, a 4-step process. The employer is supposed to tell the employer of an injury, unless they know from another source, like they saw the beam fall on his head. Then the employer bears the burden of informing them of the rights and providing a claim form. Then it's up to the employee to file the claim form. And it's filing the claim form that starts the 90 days ticking. A lot of people think that if they have notice or knowledge of it from any source, the pre-Honeywell standard, that's when the 90 days starts to tick, but it isn't. It's when the employee files the claim form with the employer, which is something that's important to know as a petitioner. Or important for the defense attorney not to know if you're an applicant's attorney petitioner. And that mistake is made a lot. You'd be surprised. I interview lawyers all the time, and I'd say at least half of them don't know that, which is shocking to me. And I don't hire them.
Not the ones that work here, exactly.
The ones that work here know that. Yeah. Well, if you don't know that, what else don't you know? Anyway, so I don't think you have to provide a claim form until it knows of an injury, a work-related injury. I guess we got ahead of the slide a little. But I think it's just that's a situation. If the employee says, I believe that this was contracted on an industrial basis and I have an injury and I'm sick, that would trigger the duty to provide a claim form. If there was a medical report or some documented evidence or any other document that alleged a work-related cause of the virus, that would trigger the duty to provide the claim form. But absent that, it's hard to see it. What if an employee is quarantined? That is, what if Bob gets sick and then you send Joe, Lucy, and Sally home because they work next to Bob? So they're being quarantined, right? They're being sent home not because they're sick. They're being sent home because they might get sick. They may have been exposed to it. They're being quarantined. Do they get workers' comp benefits? Well, it seems like they should, because it's because of a work-related issue that they're being of injury or sickness that they're being sent home. But the answer is they don't. They don't get that, and the reason is because they're not injured, and people only get workers' comp if they're injured. So some employees work from home and continue to earn money. Some go home and don't earn money and don't work, but only the injured, work-related injury cases actually get benefits. So I have a couple of cases on that here. You know, you probably have never heard of them because this just never happens up until now. Wouldn't be an issue, but I've never even heard of quarantine. But an Arrowman, a nurse, was exposed to chicken pox. She was exposed, but she didn't have chicken pox, but she might be carrying it. So the employer said, well, you can't return to work until there's no longer any possibility that you might be infectious. The applicant got 3 days of accrued sick leave, but then didn't get any TD benefits and didn't get any pay for the other 7 days she's off work. She's like, hey, you know, it's because of work that I'm not making any money here. And she didn't get the chicken pox, and the court held that she's not entitled to workers' comp benefits. She might get other benefits that the employer provides, and Eric's going to talk about that, but it's a prophylactic layoff. There's not an injury, and so without an injury, there's no benefits. There's another case called Armenta, and that was a real recent case, 2019, where the injury applicant says, hey, I had asbestos exposure. And the treating doctor says, well, now you have an increased risk of developing asbestosis, asbestos-related lung disease in the future, but it may never happen. It may take decades to develop. And the QME said, yep, that's right. And then the applicant said, yeah, but I have to monitor my chest because of my increased susceptibility to asbestosis. And you should pay for that. That's medical treatment. And the court said, no, you don't have an injury. You have the greater increased chance of getting an injury. So the monitoring of asbestos was not considered treatment for injury because no injury existed. And thus, again, the applicant on a prophylactic basis, an applicant in quarantine is not considered to have work-related injury, will not receive benefits. Now, you can have a voluntary provision of benefits to employees, right?
Yeah, so the questions come up in the employment world is, what do employers have to do and what could they do? Employers can and have been implementing provisions to provide employees relief when they have to be quarantined, when it's a prophylactic, when they have to have time off and making it paid time off. An example is Walmart did that with many of its employees. Other organizations have been doing that too. Can you do that? Of course you can. The caveat to that is you want to, when you make these provisions, make them very concise of when they apply, how long they apply, when they expire, and if they carry over to the next year. So if you're going to have a provision like this, make sure it is well drafted, because if it's done in haste, there's probably going to be issues with whether or not it continues in perpetuity. So be careful with those, but although it can make sense, especially with the larger organizations. Now, we want you to, as we said earlier, pay attention to the state, the federal guidelines and websites, the CDC, the WHO. This is from the DIR, Department of Industrial Relations website. It has a table with the types of benefits that employees may be able to get. I've heard more than a dozen times in the last 2 weeks of clients calling me about tweets from local and state and federal authorities that misinterpret and misapply the law. Don't look at the social media. Please avoid the tweet.
But it has so many other benefits. So much other truth is spoken.
There, at least at a minimum, it's entertaining. But don't get your employment advice from a tweet, because many of them had to take them down after outcries. So what benefits are available for the person, the employee who actually is diagnosed with COVID-19, they and cannot work and it's medically certified, they can get the SDI benefits, short-term disability benefits. For the person who has to care for somebody who is either diagnosed or medically certified to be quarantined because of COVID-19, paid family leave may apply. No, paid family leave does not apply to somebody who just has to stay home because their kid's school closed. There's other benefits that may be out there for that I'll talk about in a moment. Unemployment insurance available for those employees that can't work because the employer either shut its doors, sent them home, didn't provide hours. So those employees and potentially the employees that we send home and we say you're displaying symptoms, you cannot work, would have unemployment insurance benefits because their hours are reduced. So the important and paid sick leave. Remember, California in 2015 implemented paid sick leave laws that, and sometimes it can be a bit complex of the calculation, but it's really important now, and this is to make sure that your sick leave is compliant. Local ordinances can be even more strict, for example, San Francisco, San Diego. So take a look at the paid sick leave. Just because you have an unlimited PTO policy doesn't mean you don't have to comply with the bare minimums of these sick leave policies. So take a look at those. And we can't get into them in too much depth, but that's going to be really critical for now and potential litigation in the future, which I see as one of the issues we're going to be seeing. So these are the options that employees have. When it comes to EDD benefits, I tell my clients to stray away from discouraging employees from applying for these benefits. Let them apply for the benefits. I find more often than not when employers step in and say, well, you know, you shouldn't get unemployment insurance, and they do objections and oppositions. It usually ends up hurting the business more than it does help it. In very rare cases, I would recommend an objection with the state agencies. Normally, I just recommend let them apply, and you have to answer the application questions that the state will send you. So let's see. Application for, and we talked a little bit about this, EDD, it gives you employees who are unable to work due to having or being exposed to COVID-19, and again, certified by a medical professional. This is not fear of or being in a category of individuals who are in a risk factor. They have to actually be medically certified. Employees who are unable to work to care for an ill or quarantined family member, also medically certified. And if you either reduce hours or shut down, you're going to have those benefits available, which are all of those employers that are in shelter-in-place locations. So EDD is going to be inundated with those requests.
Well, I hope there's enough medical professions to certify. I wonder how you certify that you need to be quarantined. Is that, I think doctor just says, yeah, you should be quarantined.
In cases that I hear, it's people who present to their medical provider that are showing symptoms and enough symptoms to where they need to do a testing.
What if they just say, you know, it's so prevalent that I shouldn't be at work, I should be home quarantined?
If they get a medical certification to do that, but them alone saying that will not satisfy an EDD requirement.
Okay, so they got to have something wrong with them.
Or at least well, how hard is it to get a medical certification normally? Now it might be a little bit more difficult.
But what about the nurse was exposed to chicken pox? She had 3 days of sick leave, and now can she go get disability because she was exposed and she might have it, or she might have been exposed and might have it?
Disability, if it's medically certified, if the employer sent her home and she didn't have hours, definitely unemployment insurance.
Unemployment.
Yep.
Not disability. Okay.
Yep. Well, because she actually didn't have it, she wouldn't get disability insurance for sure. It'd be UI, not SDI. Okay, relief for employers. We put this up here so you have it. There's a bunch of different programs out there for employers, especially small businesses that are going to be feeling the brunt of the downturn and the ultimate effects that COVID-19 is having on our economy. So that's there for you, and I see new ones every day as well. So it's important to keep an eye on those. This is where I'm getting a lot of my questions. Disability-related inquiries, medical examinations.
So this is where an employer decides, you know what, I'm going to send you to a medical exam to see if you have COVID-19.
It doesn't even mean you have to send them for a medical exam. It could mean an employer sees an employee, says they don't look well, and requires them to have their temperature taken. Requires that we take your blood pressure.
What if they just ask them, how you feeling? That's different.
That is, and we'll get
into that.
We're getting into that.
Okay, so now we got to ask ourselves, under what conditions can an employer have an employee examined medically to any extent?
Yep. By
a physician, or even, let me feel your forehead.
Yep, absolutely. Okay. So, so the ADA and FEHA, when I say ADA, I mean both. ADA is the federal, FEHA is the more restrictive Federal Employment and Housing Act that covers disability issues. It is prohibited to make disability-related inquiries to employees except in certain circumstances.
And requiring medical exams.
And requiring medical exams.
Okay. You can make the inquiry.
No. So let's do one at a time. So okay. Disability-related inquiries are prohibited. So let's start there. And what is a disability-related inquiry? It is, and I have some examples here. For example, if you ask somebody if they have an immune system that is compromised, if you ask them if they are getting chemotherapy treatment, if you ask them if they have, if they've tested positive for HIV. These are disability-related inquiries that are prohibited under both ADA and FEHA.
How you feeling today is okay.
How you're feeling today is absolutely okay. So by contrast, non-disability related inquiries are the kinds of things that ask about conditions that are related to fevers and colds, those types of things that do not rise to the level of considered disability.
Oh, well, that would be coronavirus.
What's that?
That would be coronavirus.
Well, coronavirus in its current state, from everything we know, falls into the flu, cough, cold type of inquiries, which are permitted. So
Eric, do you have coronavirus? Have I just violated the ADA and FEHA?
No.
Wipe that mic down. Swarm, swarm, swarm.
Oh my gosh, we have people actually doing that. So do you have COVID-19? Well, this is the thing. Asking people if they have tested positive for COVID-19 at this point is the same as if you're asking them if they have the flu. Asking somebody if they're how they're feeling, if they're having symptoms, coughing, sniffling, the kinds of symptoms that Mike talked about towards the beginning, permitted and okay. Now, if these employees say, yes, I don't feel well, I've had a dry cough, and they start listing the symptoms that they have. So what do you do with that? Well, one, you don't tell everybody in the office, but you do send them home. You do mention that, oh, thank you, Mike. You do mention that to other employees that people are displaying symptoms, but do not mention their name. If an employee says, I have tested positive for COVID-19, obviously you send them home. If the employee says, my grandmother tested positive for COVID-19, I spent the evening with her last night, you send the employee home. You do not disclose why the employee went home, but you do disclose that there might be a risk in the office. That doesn't mean you send your entire workforce home unless you have a shelter-in-place type of rule that applies. What's a medical examination? And I get this question a lot just when we're dealing with regular ADA, FEHA issues. We also have a accommodation seminar we did today as well that will be available for you. that talks a little bit more in depth about fitness for duty and medical examinations. But what's a medical examination is a procedure or test that seeks information about an individual's physical or mental impairments or health. And the kinds of things that are like that are checking for fever, temperature, blood pressure, the kinds of things a doctor would do. Now, this doesn't mean, and what often is done by employers, especially in the construction industry, et cetera, show me that you can walk up that flight of that ladder, bend and stoop. Can you lift this 35 pounds? That's not considered a medical examination. What we are at, where we're at right now is people who are tempted to take vitals of people. That's a medical examination and not permitted at this stage.
Who's tempted to do that? That's weird. You never know, though.
You'd be surprised. Yeah. You'd be surprised, or maybe not. Let's see. Okay, medical examinations and when you can do them. Before a conditional offer of employment, this is before you offer an employee a position with a job. Can you do a medical examination and make disability-related inquiries? The answer is absolutely not. After a conditional offer of employment, medical evaluations are permitted to the extent that they relate to the essential functions of the job of that individual as needed. What happens though when somebody, for example, tests positive after a conditional offer of employment? Can you rescind the offer? And the answer is no. Then you have to get into a determination of what accommodations can you do. Obviously, COVID-19 for the most part of the population is a temporary condition. So you should not be rescinding those employment offers because somebody has tested positive for COVID-19. Okay. During employment, we're not talking about pre-offers or conditional offers of employment, but actually when somebody is employed, your existing employing workforce, you're not allowed to do these disability-related inquiries or medical examinations, but there are exceptions to the rules, as always. The big two are an employee's ability to perform essential job functions will be impaired by a medical condition, and usually that's when somebody has returned to work, has a clear objective inability to perform the essential functions of the job.
So they come to work in a wheelchair and they're going to work in the warehouse, and you say, you know what, you're going to have to go see a doctor.
Yeah, somebody comes to, and what we normally see is somebody has usually an industrial injury, and they come back free to work, no restrictions, and they cannot climb the ladder. They clearly, objectively, everybody in the warehouse can see they cannot climb a ladder. They cannot bend and stoop.
That's going to be a lot of gray area there.
Yeah, and these are sticky areas of doing medical examinations, and you want to do it with the help of a medical professional telling them what you see, and two, your legal professional saying, I want to send this person to a medical examination.
With the coronavirus, it's not really that pertinent because if a guy comes in sniffling and coughing, then you don't want to send him to an exam because you're just going to send him home.
Exactly.
It's not really, we're not really going to struggle a lot with whether to send. Well, under what circumstances might we struggle with sending people to a medical exam? Maybe once we developed the testing, right? We might say, go get testing before we let you go back to work.
When we have the testing, and also, and it's usually not this first exception we're talking about that's really going to apply. It's going to be employers that think it poses a direct threat. When the CDC determines that the COVID-19 is a direct threat, maybe not this month, but in the months to come, and then employers are concerned on an ongoing basis of, is this a direct threat? Can I send them for a medical examination because they're displaying symptoms?
See, because what I'm going to want to do is say, okay, we're coming back to work, folks, but everyone's going to get a test before they're allowed back in the door. Can I do that?
You can require everybody, as long as you do it consistently and apply it throughout evenly, to have a medical certification that they are safe to return back to work.
Even if they don't demonstrate any symptoms?
As long as you do it consistently.
Mm-hmm.
And this is, and you have to
understand.
I'll do
it for everybody.
You do it for everybody. As long as you do it consistently, the problem becomes, if you require that of your entire workforce, there may be a problem for the employer because they have 500 employees that need medical certifications.
It's gonna be a problem if they don't, though, because if everyone doesn't get tested, the one person that does it might have it, and the next thing you know, everybody's got it.
In that case, as it is now, my recommendation would be you require it of the people who have gone home because they've displayed symptoms, they have actually tested positive and you're aware of it, they live with somebody who tested positive or displays symptoms.
Not me. I'm gonna make everybody do it.
Okay, great.
It just can't be safe. You don't know.
But generally, we're just for the general public.
Yeah.
You don't have to do that. That's not a requirement, and it may not be practical for many employers to do.
Okay.
So, but can you do that? I believe you can. And again, we're in unprecedented territory with the widespread knowledge of what the threat is and the risk of spreading. Not necessarily that COVID-19 is necessarily going to cause everybody demise, but the fact of its spread and what we're trying to contain. It's a legitimate business reason to require a medical certification for people to come back. Along those lines, also requiring medical certification for people, like I said before, who have been traveling to certain countries that are on, the radar of being a threat for having COVID-19. That is okay. It's just documenting it and making sure you're administering these policies to everybody. If you're going to have everybody do a medical certification, there is no exception. There's no exception. Okay. Direct threat is, and right now, just so everybody knows, we are not in a place where COVID-19 has been considered a direct threat by the CDC.
I'm sorry, but under what circumstances, why do we care about what a direct threat is?
That's when you can do what we consider medical examinations.
Oh, okay.
Yep. And this is probably not around the time now because we're sending everybody home. This might be in those times where everybody returns, but now employers and employees, we're back to our work, we're back in the office, somebody coughs, does every time somebody cough in 2021, do we send them home? So we have to, do we take their temperature every time somebody coughs in 2022? I mean, there has to be a limit. So direct threat will be, you have to prove direct threat if you're ever going to do these, checking somebody's temperature, that type of thing.
Well, in this case, we're talking about a test to see if you have it.
No, a medical examination, direct.
Because that's what it'll be. I mean, that's what we'll want to do. We'll want to have them tested to see if they have COVID-19.
COVID-19, yeah, and that would be another medical examination. You would have to show it's a direct threat.
We're not going to want to take their temperature. We're going to want to send them to get a test.
That applies, exactly.
Yeah, okay, sorry.
Right. So for direct threat, if you're in that position where you're wanting to send people out for tests and they haven't displayed symptoms and you just want to be sure, you have that what's taken into consideration is one, the duration of the risk, the nature of the severity of the potential harm, the likelihood of the potential harm will occur, and the imminence of the potential harm. And if we're in a contained period where the circumstances and the number of COVID-19 documented people who have it goes down, you're not going to be rising to this direct threat level where you're going to be able to require people to have a COVID-19 certification.
Well, wait a minute. I thought you said that if you have everybody out for work, right? And you want to bring them all back, you could have everybody tested because it would be, they could be considered a direct threat. That would be the basis of having everyone tested.
The direct threat analysis isn't the reason that you can have everybody.
What is the reason?
The reason is everybody's being quarantined and sent home because we are in a position where we're trying to stop the spread of it. So
it's not a direct threat. It's it's the other exception.
Yep.
It's the
the exceptions I'm talking about now are employees that are actually here, not people who are returning. Not somebody not that person who had the cough that you sent home, and comes back. So we're talking about doing medical examinations for employees that are here right now.
Okay.
For Ian, we want to test your temperature.
I'm sorry to keep pressing the point, but I just don't understand.
That's okay.
If I have everyone at home and I want to bring them back, but I want everyone to be tested, I can do that.
What you need, you can have them have a medical certification to say they can return to work and they are not.
Oh, okay. It's not the direct threat. It's it's the other exception that you're referring to.
What we're talking about now are fitness for duty, medical examinations, those types of things.
So once they're back to work, then I'm gonna have to show their direct threat before I can get them tested, which is a bummer because the standard's gonna be relatively high.
It will be. It will be. And I mean, honestly, it should be, because what we're talking about are and why this is such a tricky area of law is because the privacy interest of people's medical information, what they test positive for or don't test positive for, it's highly protected. And that's why there are these exceptions, but they're few and far between. So we're not going to get into a world where we can just test people on the fly.
Okay.
Sorry.
No, I'm sorry. I keep interrupting.
No, not at all. So on reasonable accommodations, and I told you before we had another presentation today that went into depth on the issue, and we brought up COVID-19 issues. But for the purpose of this discussion, reasonable accommodations are required for disabilities. Now, the question comes up, is COVID-19 under either ADA or FEHA a disability? And the answer is probably not. But the lawyerly answer I always have is, it depends. It depends on the individual, how it's impacted them, how long they're having the symptoms. Is it having an impact on their ability to perform major life activities? So the example I typically have, and I've had before when I do my reasonable accommodation seminar, is the pneumonia. Is pneumonia a disability?
I don't want to embarrass you, but it's pronounced pneumonia.
Oh, thank you. That's why I have
it's got a P on the front.
Is pneumonia a disability? And because we know from case law that flu and cold, those don't rise to a level of disability. Is pneumonia a disability? I had a case like that went to trial, a 2-week trial, and it was a disability related. The question was this person discriminated against because they had pneumonia for 2 weeks? Now, caveat, of course I won the case, otherwise I wouldn't bring it up, but the 12 jurors, as a foundational question, 12 people said under California law, pneumonia was a disability. So it's one of the reasons I tell my employers, if you're going to make a judgment call about an accommodation, it should not be whether or not you consider it a disability, because it is an area of California law that is so loose for employees. Most anything can get under the radar except for maybe flu or cold. So how does that work with COVID-19? Pneumonia can be a more extreme version of somebody who has the flu. It gets into the lungs and becomes more severe. COVID-19 for certain people can become more severe, where it may rise to the level of disability. So that's not where I want my clients to make a judgment call. If you're accommodating somebody because of COVID-19, determine it based on whether your company can provide a reasonable accommodation to perform the essential job functions. Note that when you're making those accommodations, you don't have to remove essential job functions for them to perform a job. You don't have to create a new job for these people. But where it's probably going to happen is remote work. Remote work is going to be the big accommodation that's going to be requested for people who have suppressed immune systems, who have had chemotherapy treatment, who have some type of medical certification that they are at higher risk and need to work remote. These are the kinds of judgment calls employers are going to have to make. And the argument that employees are going to have when they're sent home, everybody's working remote, this can't be what we call an undue hardship employer, because you already sent us home. We already worked remote. So what I recommend for my clients is, yes, people are in an emergency situation, can be sent home, have an acknowledgement so the employees understand this is for a temporary emergency situation, but they are still required to perform their essential functions when they return, which may include, and for many jobs do include, being present in the office. so that is my recommendation, because I see this as going to be a big issue going forward. Okay, let's see. So, and we're kind of beyond this. Before a pandemic, when I was writing this, I thought this might be something that you guys might want to see, but we're already in a pandemic. But I'm still going to put this in here because it's important. The EEOC has put down guidelines to where an employer can make certain inquiries to its employee base to find out who or how many might be affected by a pandemic that might need to go home. And that's for perspective looking to see how your workforce is going to be affected. This is pulled from the EEOC website. This is an approved form. And the reason it's approved is because it asks questions broadly, and it doesn't ask the employee to answer each question yes or no. It asks the employee to answer the question at the bottom, yes or no, if any of the above applies.
We were going to use this form on Friday, and then on Monday it was a pandemic.
And we didn't need it.
Yeah.
Yep. And the purpose of that, and where it would have been and might still be useful for some employers out there, is to determine which employees should go. If you want to do this in waves for a contingency plan, you want a certain office to go or a certain group of people to go. These could be the people that are first on the list, as so you're not sending everybody home at once. In California, likely it might be too late for that, but this is available to you on the EEOC website. All right, new hire employees. Oh, we kind of talked about this already. Post-offer medical exams. Nothing new here for me to talk about, so let's go to the next one. Yeah, so may ADA covered employer send employees home if they display influenza symptoms? Absolutely, yes. And this has been in the guidance I have here is not just case law, but we have EEOC and DFEH guidelines that say this is okay. I understand my HR people out there are terrified about sending people home because of any kind of medical condition, but this has been vetted already, and it was vetted during the H1N1 period. So we have at least some guidance today to where we can do this. How much information may an ADA covered employer request from an employee? Again, they can ask if they're experiencing influenza-like symptoms, the cough, the fever, the chills, but you have to maintain the confidentiality of that employee. You can't just say, Bob has a fever. Everybody, get away from Bob.
Run for cover.
Yeah. So you have to maintain that kind of confidentiality and keep it in a confidential place as you would any other medical information in your organization. During a pandemic, is this the right one? Yep. During a pandemic, may an ADA covered employee take employee's temperature? We already talked about that.
No.
Not
keep your hands off the merchandise.
And it really, and Mike, why would you want to? If somebody's displaying symptoms right now in the environment we are currently, you send them home. You can send them home. You should send them home. When the employee returns from travel, must an employer wait until the employee develops influenza symptoms? No. Again, if you apply this consistently throughout your organization, people have traveled to risk areas, you can require them, and what we suggest is the 14-day period of time, and you can require medical certification for them to come back.
We actually did that. An employee went on a trip and we asked them to stay home for 14 days.
Yep. Asked them to go home for 14
Everyone's
days.
going home now, so what difference does it make?
Right. But do you get the medical certification when they come back? Yeah, I would. So let's see. During a pandemic, may an ADA covered employee ask employees who do not have influenza symptoms to disclose whether they have a medical condition that the CDC says could make the especially vulnerable to influenza complications? No, you cannot. These are disability related potential inquiries. And the other question I had at my other webinar earlier was, okay, we have a large workforce that's over 65. Can we send our employees that are over 65 home because they're in a risk category? And the answer is no, absolutely not. And why? Because what you're going to be facing is an age discrimination lawsuit.
Bob, you're old. Go home. We don't want you catching the coronavirus and dying.
And that's the way it's received, and that's the lawsuits that we're going to see. If you're going to be sending people home, they have symptoms, somebody they're living with has symptoms, or they've tested positive. And if you're going to be sending the people over 65 home, you send everybody home. So that's my word on that. Okay. During influenza pandemic, can you encourage employees to telework? Right now, many places don't have a choice. So yes, you may, you may encourage them to telework. Again, when you're doing this, keep in mind of what it's going to look like when they return. Make sure your employees understand that they still have essential job functions that they have to perform when they come back, one of them being working from the office. Otherwise, you're going to be faced with everybody wanting to work from home in perpetuity. During a pandemic, may an employer require employees to adopt infection control practices? Yes, absolutely. And we talked about that a little bit earlier. And we're pulling these questions from a lot from clients that have posed these questions, so we figured the general public might have them as well. May an employer covered by the ADA Title VII compel all of its employees to take the influenza vaccine? And the general answer is no. You can't compel people to take a vaccine. You can recommend it. You can make it available. There may be exceptions where, for example, religious beliefs, where people have religious beliefs that are against taking vaccines.
A lot of people think they'll believe in vaccines. They think there's a big fight about that, right?
Absolutely.
They don't vaccinate their kids and everyone's mad at them and they're mad at the other people.
Yep. So ADA, Title VII, FIA guidelines all say you can recommend it, but you can't demand it. And there may be exceptions to certain healthcare industries, but as of now, generally, no, you cannot. Okay, during a pandemic, must an employer continue to provide reasonable accommodations for employees with known disabilities that are unrelated to the pandemic? And absolutely, you do. To the extent you can, and everybody's, life is upturned and everybody's scrambling, but the accommodations that you have in place for employees that have known disabilities, you have to take all reasonable measures to keep them with those accommodations, even if they're working from home. Okay. An employee with disabilities whose responsibilities include management during a pandemic must receive reasonable accommodations necessary to maintain their management position. So it goes
that
hand.
Means they have to provide me with a lot of rum.
My accommodation is tequila, so I'm with you.
Okay.
During a pandemic, may an employer ask an employee why is he or she been absent from work? Yes, you're always allowed to ask your employees, why are you not at work? And that goes hand in hand with if you see they don't feel well, what, fever, chills, that type of things. You can ask those questions as well. And I understand why employers get a little skittish about asking questions, but you are entitled to ask where an employee has been. Now, the one caution during this period of time I want employers to take is, although COVID-19 in most cases probably does not rise to a level of disability under either ADA or FIHA for the most part, how you treat employees could make it protected under the disability laws. It's called regarded as disabled. So an employee need not be actually disabled by COVID-19, but if an employer treats them as if they're disabled, regards them as disabled, all of the protections, accommodation laws, interactive process, all of those laws go with it. So make sure you're not treating people as disabled, and this goes for COVID-19, this goes for any condition, that you do not know for a fact the employee has a disability. Okay, I'm getting off my soapbox. What's the next thing? Okay, may an ADA covered employee require employees who have been away from the workplace during a pandemic to provide a doctor's note?
That was what I was asking about before.
Yep. And you may. So we got into that one.
But I can't wait. I can't every month require a doctor's
You may
test.
not.
I can't. Once I get back in, I got to show egregious threat. Direct threat.
Direct
Yeah.
threat. Direct threat. Oh, don't get Mike started.
Yeah.
Okay, so now to the fun part, wage and hour compliance. We talked a little bit earlier about reimbursements. When you're sending these people home, they're working remote, and a lot of these people are going to be working with their cell phones because you need to contact them. Any use of devices, equipment, any money that's expended by the employee as a direct result of performing work for an employer must be reasonably reimbursed. Does that mean you pay their entire internet bill and their cable bill? Absolutely not. It's a reasonable amount, proportional to the type of work they're doing and how much work they're doing using that service. So you don't have to pay their full phone bill, but you do have to pay a reasonable part of their network service for taking calls.
Is it the
email.
percentage that you would use for work, or how do you determine
Well,
what's reasonable?
It's California law, so reasonable is not well defined. So it depends. It depends. My recommendation to my clients is put a flat rate out there that you pay on a monthly basis, and leave it to the employee to make the requests for reimbursements that they think are in excess of that amount, and to provide documentation to prove it. And make sure you're keeping track of what these employers are using, they're taking. All of that is going to make a difference in the long haul. Paid sick leave, and we talked about that already. That's going to be a biggie. Make sure your paid sick leave laws have, at a minimum, comply with your local and state and California state ordinance that came up in 2015.
Well, you should be doing that anyway.
You should be doing it anyway, but you would be surprised. And make sure you understand that just because you've imposed greater sick leave days or time, you still have to comply with the mandates of the sick leave law. Meaning there's certain days you don't have to have a doctor's note for the first 3 days, and you can't retaliate for people taking sick leave. All of those laws apply regardless of whether you have a more beneficial paid sick leave than state or local ordinances require. Okay. If an employee exhausts sick leave, can other leave be used? Yes. And it really depends on your policies. So make sure your policies are clear. If you have an unlimited PTO policy, make sure it's clear as to what it applies to, whether it applies to extended leaves because of FMLA, CIFRA leave. Typically, those are excluded in unlimited PTO policies.
Short-term disability, maybe.
So short-term disability might be available through state. And we're going to get into HR 6201, which is the federal law that is changing as we go, just past the Senate, and I'll get into that in a second. Can you require them to exhaust their paid sick leave? No, it's at the employee's
if they're
option.
quarantined.
If they're quarantined, it's at the employee's
so they
option.
can take they can say, I'm not using my sick leave, just don't pay me.
Yep.
Who's going to do that?
People who want to keep it in the bank for some reason.
Okay.
But you can't require it of them. All right. Okay. Like daycare, school closes, daycare closes. What do I do? This goes into the other leave category. For employers with 5 or more employees, an employee gets 40 hours a year, typically 8 hours a month, but in emergency circumstances like now, 40 hours in a year. That's not limited to the 8 hours a month to care for the child or engage in these school activities.
Wait a minute, is that paid?
Unpaid.
Unpaid.
Unpaid leave.
So I didn't know that. I mean, if your kid comes home from school and you can't take care of them, you get 40 hours unpaid leave per year before you can fire them for not showing up at work.
So the 40 hours, it goes for these emergency shutdowns, those types of things. That's where this leave comes into. It also, other subsections of this law go to school activities, having to go to see the principal, other school mandated things. Those are typically limited to 8 hours a month, up to 40 hours a year, unpaid leave. Yep. And those are protected leaves. Can an employer require a worker to provide information about recent travel? We already talked about that. Yes, you may. Is an employee, how long do we have? Okay. Is an employee entitled to compensation for reporting to work and being sent home? Generally, yes. This is called reporting time pay. You need to pay your employees who report to work, but you send them home for whatever reason, with exceptions I'll talk about, for at least half of their scheduled shift, for at least 2 hours, and no more than 4 hours. I have an example here. A worker who reports to work for an 8-hour shift and only works for 1 hour must receive 4 hours of pay, 1 hour, 1 for the hour worked, and 3 as reporting time pay, so that the worker receives pay of at least half of the expected 8-hour shift.
That was on Better Call Saul last night.
What's that?
That was on Better Call Saul last night.
Yep.
Yeah, the workers showed up at the site, and then Saul screwed up their work day.
Yep.
And they got a half day of pay.
Half day pay, reporting time pay.
Yeah.
Now, in these circumstances where a state of emergency is declared, reporting time pay does not apply. That doesn't mean that the employer shuts down out of precaution. It means that a state of emergency says everybody must go home now. And so the reporting time laws would not apply.
That surprises me. I thought it would have come down in favor of the worker.
Because we're in California, I agree.
Yeah.
Sometimes we get surprised. Now, this is about exempt employees. I'm not going to go into great detail, but just understand that exempt employees also have a kind of reporting time requirement. If they work during a week, they're entitled to their full week of salary. If the employer fails to make the rest of the week available for them. Again, if work is available to them, but they don't take it, obviously they're not entitled to the reporting time pay. If they don't report to work all week, they do not get the full weeks of pay. And then there's some details here about deductions of salary. I'm not going to get too much into because we need to talk about HR 6201, which is the federal law that was passed last week on Friday by the House, has been up by the Senate. And I had told people I didn't really want to talk about this yet because it's being sliced. I knew it would be sliced and diced, and it has been. It has not been, well, at least since we've been talking, it has not been signed by the president yet, but it did pass the Senate floor after being sliced and diced. So what I have here is what it was as of Friday, and I'll tell you what the differences are now. There's several components to it. Some of it has to do with providing meals for seniors and kids. We're not going to get into that. We're going to talk about the two that really directs the wage and hour issues and the leave laws, which is the Protected Family Medical Leave Act and the Emergency Paid Sick Leave. So originally, and this still applies, this applies to employers with 500 or fewer employees to give their employees up to 12 weeks of job protected leave because I'll get to the reasons why, but this is in addition to the FMLA that already applies. The difference with this law is it provides paid leave during 10 of these weeks. So,
wow.
Exactly. So 10 of the 12 weeks are to be paid at a rate of no less than 2/3 of the employee's usual rate of pay. That's how it was when it went in. They put a cap on at $200 a day up to a total aggregate of $10,000 during those 10 weeks. The first 2 weeks can be unpaid. The employee has the right to use other paid leaves to supplement during that period of time. It was originally, for all of the reasons potentially here, the new FMLA language just is now for to care for a child of an employee if the child's school or place of care has been closed or the child care provider is unavailable due to the coronavirus. The other two have been excluded as to the last version I've seen. And it says still the first 2 weeks are unpaid and no less than 2/3 of the pay, except for the caps that I just mentioned. That still is in play.
Well, FMLA has never been paid.
What's that?
Yep.
FMLA has always been an unpaid leave.
And they can take it if their kids are home from school and still get paid.
Correct.
Wow.
Well, if their kid is home, yes. If the school is closed.
What if we send them home? Can they still take the FMLA and take care of their kids?
What if you send them home
and work? Say, go home and work. Don't work here, like we did.
Well, an employee whose kids are home from school and they have to care for them may have an exception not to work. They may not have to work remote.
Right, and so they get paid.
Because this is protected.
They get paid
at
if their kids are home from school.
At 2/3.
So we're gonna have to be aware of that.
And it's protected. And
Yeah.
it's protected.
Okay.
Well, assuming it's signed by the president without any further changes, which I don't expect at this point. There's exceptions that are in play if employers with less than 25 employees, if the employer's job no longer exists due to the coronavirus pandemic. And it also adds some exceptions for small businesses with fewer than 50 employees can apply to be exempt, and certain healthcare providers. Those exemptions are still in play last I checked as well. The other is the 14-day of paid sick leave, which has been now whittled down to 2 weeks or 10 days of paid sick leave at the last version I saw. So it's 2 weeks. Also now it has a cap of $511 a day and the cap of 80 hours. So it does have caps now where before it did not have a cap. Employers with fewer than 500 employees will be required to provide full-time employees with 2 weeks of the paid leave. And the reason being for all of these, self-isolate because of diagnosis, to comply with the recommendation or order, to obtain a medical diagnosis or care for employee experiencing symptoms of coronavirus, and to care for a family member who is self-isolating due to diagnosis, and also to care for a child whose school has been closed. So this will work in tandem with the FMLA, emergency FMLA, and coincidentally has those extra 10 days, which it appears they can use this 10-day period under the emergency paid sick leave to supplement those first 2 weeks.
Well, it's a good thing this isn't complicated.
It's, and believe me, I just had a brief moment to take a look at the revisions. So we'll need to do a further analysis at the final form, but we don't have a final form yet. One of the things to keep in mind, it's available for all employees immediately, regardless of how long they have worked for the employer. And you cannot force them to use this leave first, or force them to use other leaves first. Say, oh, you have other paid sick leave, use that first. You don't get the option to do that. The employee gets the option to use whichever leave they desire first.
I was wondering about that.
Yep. Let's see. The part-time employees. Even in addition to all of these stay in place as well as far as I last read. And because we're running short on time, local ordinances. I just want you to be wary of your local ordinances because a lot of times those slip through the cracks for employers, especially when they have employees in a city, but they don't necessarily have boots down in that city. Make sure your HR people are paying attention to the ordinances. There's a new one with San Francisco I put up here. This is just one example of many that provides some relief for employees and to the employers who are paying them. Also, there's some with the HR 6201, there's also some tax benefits and cuts for employers who are paying these benefits that they use to offset how it's impacting the employers that are paying for these emergency leaves. The other I want you to be aware of, and there's no time to get into depth on these two, into this area of law, but it's federal and state WARN Act. And this is for those employers out there who are considering mass layoffs because of the coronavirus. There are reporting times to notice times for employees of at least 60 days under both laws. There are a number of exceptions that apply depending on your business, but you want to be aware that this notice period applies. If you don't have an exception and you lay off 100 employees and don't give them the notice, you will still be responsible for their pay during that entire period of time.
60 days notice, huh? Can't
60
just shut it down.
60 days notice. And there are exceptions to it, but it's intricate. So this is the kind of decision I want you to have an employment advisor for before you make those decisions, because it could end up costing you more money than you think you're saving. And options beyond this are strategically, don't do a layoff, because if your plant or your business is closed because of state or federal order, it is not an employer action that requires a 60-day notice. So it wouldn't fall within the WARN Act. So you may not want to be doing these things anyway, because you're not actually requiring it of your employer. It's not an employer act, it's a state or federal requirement. So there might be strategies around this, and so talk to your employment advisor for that. And we're not going to get into OSHA too deeply, but I wanted to put at least the general provision up here for all employers. Other specialized fields have stricter requirements, but this is a general duty clause that I put up here for you to keep the workplace hazard-free, and the hazard has been recognized, the hazard was causing or is likely to cause a death or serious physical harm, and there was a foreseeable and useful method to correct the hazard. COVID-19 falls squarely within these requirements to maintain a safe and healthy work environment, especially when you know there's other risks out there, and putting in cleaning protocols. So be aware of OSHA requirements as well.
Lord have mercy.
Look, yep.
That's a lot.
That's a lot.
And this is just the first week into this.
There'll be more.
Yeah, there will. Like I said, it's a constantly changing environment. It's unbelievable,
Yep.
hour by hour, and it's such a severe, heavy thing in terms of illness and the economy.
And this is, I mean, beyond legal advice, this is just practical, a practical thought. Everybody's life has been upturned. Everybody's business has been upturned and is dealing with this. And the typical outlets for stress for people during times of stress are removed. Social gatherings, the gym, bars, they're not there anymore. So everybody's going to be in a period of high stress. So my practical advice is
drink a lot.
Well, that too, yeah. Well, that's usually my practical advice. But take a breath before you make any big business decisions or do a reactionary decision, and do it smartly without being reactionary, because everybody is feeling the pressure at this point. So that's and stay safe. So that's my practical advice.
Well, thanks, Eric. I appreciate you and Afsha checking in and giving us so much great information.
My pleasure.
Here's our emails. Like I said, we didn't have a lot of time. We just didn't have time to answer questions as we go. But if you have them, email them to us, and we'll be happy to take a look at them. It's certainly a great pleasure to be able to help out and provide information in this kind of time. We're going to be staying on it. We're going to be sending you alerts. We'll do webinars as appropriate. And we'll go ahead and thank you for your time.
Thank you, everybody.
Wish you well out in this crazy world.